From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Senate negotiators come to bipartisan agreement on a framework for gun legislation as the House sets a vote on a bill to give security to the families of Supreme Court justices. Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnist Kim Strassel and editorial board member Kate Batchelder-Odell. Welcome to you both. On Sunday, a group of 20 senators, both Republicans and Democrats, announced that they had come to an agreement on a framework for some kind of gun legislation. That number of 20 senators is notable because it includes 10 Republicans, which is the number needed in a 50-50 Senate to end a filibuster and pass a bill. And here is Democratic leader Chuck Schumer on the floor on Monday reacting to this framework.
For the first time in a long time, the Senate has a path forward on legislation that will save lives, reduce gun violence, and keep our communities safe. Make no mistake about it, we have a lot of work left to do before we actually pass a bill. But yesterday's announcement was a positive and necessary step in the right direction. Now comes the important work of turning this framework into legislation and legislative language that can pass Congress and be signed by the president.
On the other side of the aisle, let's listen to one of the Republican negotiators, Senator John Cornyn of Texas.
I said at the outset I would not support any additional restrictions on the rights of law-abiding gun owners. There are hundreds of millions of guns in America today, and the vast majority, almost all of those gun owners are responsible. They're not a threat to public safety. And so, this being a constitutional right to keep and bear arms, there is no basis to restrict the rights of law-abiding gun owners or to restrict the constitutional rights of any of our citizens. I made clear this is a red line of mine from the outset, and this bipartisan agreement on principles makes good on that commitment.
Kim, what is in this framework and what do you make of it?
Yeah, okay. So, by the way, I totally agree with John Cornyn that one of the reasons that this is actually moving ahead and that you got these 10 Republicans is because for the first time in a very long time, Democrats agreed to climb down from some of their absolutism on gun restrictions and attempt to try to deal with what we know is the actual problem out there, which is not law-abiding Americans and their guns, but rather young, troubled men. That is what happens to be a common element of too many of these shootings and their ability to access firearms and the lack of help for them from a mental health perspective. And so that's really what this gun bill framework is focused on. There's basically three areas. There would be some grant money for states to implement so-called red flag laws, which allows in certain circumstances a court to intervene and remove firearms from individuals who are deemed a threat to themselves or others. That would also have grant money in that bucket for beefed up mental health services. There's money for enhanced school safety. And then there's some additional scrutiny of gun buyers who are under the age of 21, basically saying that what we should be doing here is taking the juvenile and mental health records of those below the age of 18, and if they are the type of thing that would disqualify you from getting a firearm when you were over the age of 18, then they should also be disqualifying or something that people should look at in the background system now. It's not as if all of your mental health problems simply just go away or your record of criminal activity goes away when you're 18. Your behavior doesn't change overnight. And so in some ways, this is fixing a hole in the background system in which people who on the day they turn 18, everything that they've done before that is essentially a black hole. Now there would be an ability for the background system to check on what they have done. And again, if it's a disqualifying offense, that would be flagged and noted. There are a few other things in here, the boyfriend loophole, etc., but those are the main categories and buckets. And the trick here is going to be in the legislative text. This is a framework. There are a lot of details when it comes to gun laws and ways you have to protect due process and protections. That's what they're dealing with now. But overall, I think this is a really pretty impressive step forward.
To start where Kim did with the red flag law, one thing that I would point out is this is funding for state red flag laws. The bipartisan group put out the statement on this provision that says provides resources to states and tribes to create and administer laws that help ensure deadly weapons are kept out of the hands of individuals whom a court has determined to be a significant danger to themselves or others. And on one hand, Kate, I don't think lack of funding is the reason that states have not pursued these laws. There are a lot of states that have pursued these laws, in fact, and the others that have chosen not to. I don't think funding is the issue. On the other hand, maybe a little bit of federal money could provide an incentive for them to do so. The other thing I would point out is this is not a federal red flag law, which a lot of Democrats have called for. And there, I think it's a little bit trickier. First, because I've heard some criticisms that federal courts are less suited to this sort of activity because these red flags may come in on short notice. There may be a threat that is alleged. And federal courts generally don't act as swiftly on those things as state and local courts, which are dealing with, domestic violence charges and stuff like this day to day already. And also then there are issues of really what is the federal role, the constitutional role the federal government plays here. So I think this bipartisan group has been wise to steer away from a federal red flag law and instead try to do these grants to encourage states.
I think you're right, Kyle, and I'd add just one more thing to that list of why I think a state approach is preferable to a federal one. And that's because you'll get some actual experimentation with these laws and understanding of what is really effective. We've talked on the podcast before about sometimes these laws include really complicated forms or a filing fee, too much bureaucratic hassle that discourages people from coming forward, or parents are just not sure whether their child needs this kind of intervention and there's no real way to interact with the system and get some resources that you need. And then there's, of course, the due process concerns that we've discussed here as well, which is you want these laws to really have strong penalties for false allegations, for instance, and we would want to see states start to look at different ways to do that. And I think here, some seed money is much more effective for all the reasons you described than simply trying to write a federal law that might not work well in individual jurisdictions anyway.
Yeah, I just throw in there, too, a couple of more things on the red flag laws, especially at the state level. One of the reasons I think this actually could be promising is because I think it could actually potentially better some of the existing red flag laws along the lines that Kate was just mentioning. One of the reasons that some states have become wary of red flag laws is because they've looked at other states that have implemented them, and they don't really have a great amount of due process protections in them. You can imagine the kinds of states we're talking about. My understanding is that the negotiators in here, especially on the conservative side, are pushing very hard for language in the text that would say that only states that have red flag laws that have due process protections in them. And some of the things that might include is the right for the accused to have counsel present at proceedings, heightened evidentiary standards, and really severe penalties for abuse of the program, like Kate was saying. Only those would qualify for money. So there's a potential not only to maybe draw some new states into getting red flag laws, but to cause some of the states that already have them that really haven't cared as much as they should about the rights of the accused here to step up and do a better job. One other provision of this, as I'm told, is that in recognition that there may be some states out there that simply won't do a red flag law because of some of the stigma that's been associated with them, they're trying to write this in a way that states that experiment with other types of mental health laws designed to make sure that troubled youth can't access guns more easily, that they might also qualify for some kind of money.
And to the point that you made, Kim, about not focusing this legislation on law-abiding gun owners, but focusing on people who seem like they are presenting a potential threat, there's also a line in here in this bipartisan framework. It said protections for victims of domestic violence, convicted domestic violence abusers, and individuals subject to domestic violence restraining orders are included in the national background system. including those who have or had a continuing relationship of a romantic or intimate nature. And Kim, can you just explain what's going on there? My understanding is it has something to do with some people are in the background check and some people aren't, and it is described often as a loophole.
Yeah, this is what Democrats call the boyfriend loophole. So under current law, if you are found to have engaged in domestic violence, only those people in that category who are married to or live with or have a child with the victim of that domestic abuse are barred from obtaining a firearm. Democrats call this a loophole. They'd like to see a much broader definition of who counts as a boyfriend. Again, this one will be really focused on the question of legislative text. I know that Republican negotiators are struggling to kind of come up with language. You just read the one they had, the kind of broad language they had in that press release, but they want to have some sort of language that really does define, it might define people who are outside of those parameters, living with or married to or having a child with, but that nonetheless conveys that this needs to be a long-term relationship and that this can't just be applied to anybody who you've just had a casual random date with.
And the question about the legislative text, I think, also holds for a couple of these other provisions. One we've mentioned is this enhanced review process for people who are under 21. What exactly does that look like? How does that interact with all the different criminal and mental health systems that individual states have? There's also a provision that says it would crack down on criminals who illegally straw purchase and traffic guns. I'm fine with cracking down on people who illegally straw purchase and traffic guns, but what does that mean in practice? And as we've mentioned previously on these podcasts, part of the problem seems to be a lack of enforcement of the laws against straw purchasing and relying on background checks that are already on the books. And so that may be part of the reason that Republican leader Mitch McConnell is not quite endorsing this framework yet. He said the principles they announced today show the value of dialogue and cooperation. I continue to hope their discussions yield a bipartisan product that makes significant headway on key issues like mental health and school safety, respects the Second Amendment, earns broad support in the Senate, and makes a difference for our country, unquote. And he seems to be suggesting there, Kate, that the devil is in the details. And so we'll see what the text they come up with. We'll see what it says.
Yes, I mean, I think he's keeping open the option that this could fall apart. And as they try to iron out the details, I think Chuck Schumer's statement that we listened to kind of alluded to that as well. I think there is a high risk of that. There's not, for instance, any real agreement about where some of this money is going to come from, how they plan to pay for the bill. I think something that deserves a really serious look is what happened to a lot of the COVID relief money that has been given to states. And if there's some of that that's left unused, repurposing it for these important priorities. But I think Democrats will be reluctant to do so. That's one area where we'll be interested to see what materializes. And then there's, of course, some questions about, as you invest in mental health services for schools, well, how exactly is that money going to flow? Is it going to flow to the state, the school? These kinds of questions are really important on how effective these programs are going to be. And so I do think there will be quite a few details to iron out. I also think, Kyle, not to be terribly cynical here, but we're running close to a midterm election and Congress really doesn't have much time left on the calendar before it really turns into campaign mode. I do have some concern here that the deal could fall apart if either party decides they want the issue more than they want a solution. And so I do think that we have some indication of that, given that the House and Democrats passed a total non-starter bill they knew was going nowhere on assault weapons. So the question here is, can they land this plane this close to the midterms and get something done? I think there's reason to be hopeful, but there are some real details here that will need to be sorted out.
One final point I would make is just on the Democrats who are saying this might be a good step, but it's insufficient, is that we also have 50 states and 50 governors, and there's a nationalizing dynamic, I think, in our politics lately, where if something bad happens, everybody turns first to Congress and asks, what is Congress going to do? But those state lawmakers are fully capable of changing state law on guns, and in fact, they're doing so right now. New York recently raised its age to purchase many semi-automatic rifles to 21. And is that constitutional? I guess we will find out when someone sues over that law. But there is also a lot that can be done in the states if the political majorities can be brought together to do it. Hang tight. We'll be right back. You're listening to Potomac Watch from the Wall Street Journal.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. The House is set to vote today on a bill that would extend federal protection to the families of Supreme Court justices. And Kim, we talked on a podcast last week about the holding up of this bill. And before the House left town on Thursday, here is what Republican Kevin McCarthy said.
I spoke to the majority leader this morning. I told him nobody on this side would object. A unanimous consent. He could run that bill on the floor right now and send it to the president so we could protect the Supreme Court. How many times do they have to be threatened? How many people have to be arrested with a gun outside their home?
And I said last week that I was a bit mystified by why the House was not moving expeditiously to pass this bill that the Senate had already passed by unanimous consent. And we've gotten a little bit more information, Kim. It seems like some members of the House wanted to add protection for Supreme Court staff as well. Does this make more sense of what the impasse here has been?
Yeah, well, look, the Democrats were playing games, and it's a real shame because, as you could tell from the emotion in McCarthy's voice there, this is not something to play games with. And what we know is that they were working on their own legislation that would have included not just protection for the Supreme Court justices, but for their staff and clerks. And this seemed to be coming from a couple of areas. One, it seemed to be making a statement about whoever leaked that Supreme Court opinion in Roe v. Wade, that Democrats basically wanted to make sure that all attention was paid to the importance of those people as well, too. There also was a comment from, who else, Alexandria Ocasio-Cortez, saying that she felt uncomfortable passing a bill to give protection to Supreme Court justices when Congress hadn't passed a bill to protect kids because of gun violence, etc., and so on. Kind of a talking point there. In any event, as Republicans noted in the Senate, they were very critical of this. Mitch McConnell came out and said, look, we don't have protection for the staff of members of Congress. John Cornyn came out and pointed out that while the justices are well known and therefore obviously a subject of attack, the staff's names are not broadcast and the threat to them is not the same. The pressure was really mounting and essentially Pelosi caved.
And just to make clear, the Senate bill is 2 pages long. It could be 1 page if Congress used normal font sizes and normal margins. But basically, there's a law that provides protection to federal officials. It would add to that law this provision. It would protect any member of the immediate family of the Chief Justice, any Associate Justice, or any officer of the Supreme Court if the marshal determines such protection is necessary, unquote. And so I take Kim's point that maybe the members of Congress, their staff, don't get any such protection, but it also says here if the marshal determines such protection is necessary. So in normal times, you would think the marshal would say clerks, Supreme Court staff are not under any threat anyway. So it would be hard for me to see why that would apply unless there is some specific threat that is made. So, Kate, I think this dispute is a little bit strange still. I still find myself a little bit mystified whether it protects staff or whether it doesn't protect staff. Just pass the bill and let's get some security for these justices' families, their young children, and give them a more sense of security.
Yeah, Kyle, I mean, a couple things to underscore here. In addition to Kim's points, that clerks simply don't have the public profile that the justices do, while the clerks also don't vote on cases and thus issue decisions. I mean, the horrible thing that we've been warning about in editorials is that if there is a 5-4 decision on the Dobbs abortion case, that a fanatic would try to preclude that ruling from coming down by harming a justice. I mean, that is the really specific threat that the court is dealing with. And unfortunately, it became much more easy to imagine after someone showed up outside Brett Kavanaugh's house in the middle of the night. I would add one other thing, Kyle, which is, as we've been talking about, the Senate passed this bill by unanimous consent more than a month ago. Not much can get through Congress on such favorable terms these days, but there was pretty much no disagreement. And a few weeks delay, maybe Congress would just pitch that as business as usual, but the court's term is winding up at the end of this month. The threat is really acute over these next 2 weeks, and so the lapse of this bill is really rendering the bill useless if it's not going to be enacted in time to really deal with the threat that the justices are facing this month. So hopefully, to Kim's point, I think Democrats started to really feel the political pressure that they needed to get this done. And so it's expected to have really no trouble passing the House and will hopefully get a prompt signature by President Biden so that the justices and their families, as we noted, the justices tend to have some protection, but if you have school-age kids and if the security moves with the justice, the kids can be more vulnerable or family members. Hopefully we get some enhanced protection here and we can tamp down on just this bad period we're living through where the court is really at risk.
Well, let me ask about that threat. We have a letter from a listener here, Daryl in Washington State, and he says there's something that President Biden could do tomorrow that would reduce the threat. And he could say, President Biden could come out and say that if a fanatic did something that incapacitated a justice, President could say he would appoint a justice with the same judicial philosophy and would shame those senators in his own party that oppose this. If the nominee were rejected, he would refuse to appoint another until after the next presidential election. And he goes on to suggest that this is a policy that any president should hold to, that if there's a fanatic that does something that takes one of the justices out of commission, instead of using that as an opportunity to flip the Supreme Court, the president should commit to not doing that. Kim, what do you make of that?
I think it's a fabulous idea. I love it, especially the idea that, set it as a precedent. Now, I think one sad thing is that there isn't a lot of trust in Washington these days. And I have no doubt that Democrats, many of them would be outraged, especially progressives who wouldn't want to play nice that way and who would warn that a Republican president might not do the same. But we are a country lacking in those kind of grand gestures. But this would be much more than a gesture, too. It really would send a very powerful message to those out there who are so angry and on the edge of violence that there will be no upside to engaging in such acts or promoting such acts. It would be wonderful to see. I am not very optimistic it's something he would do, but I think it would be a very, very good idea.
Thank you, Kim and Kate. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button on your favorite podcast app, and we'll be back tomorrow with another edition of Potomac Watch.